serious case, yet everything the Supreme Court is doing to help Trump avoid accountability. The U.S. Supreme Court has given Trump a long-awaited reprieve from prosecution on the charges filed Jan. 6 in a Washington, D.C. District Court. Before we get started, be sure to subscribe to Celebrity Top Notch and hit the notification button to be notified when we post great videos. Let us know your possible suggestions by leaving your comments below. Wednesday night, the federal Supreme Court issued a brief order that Donald Trump's claim of immunity from prosecution for his conduct as president will be heard in oral argument the week of April 22nd. Are currently pending. No discovery will be conducted. No pretrial motions will be filed. The case is frozen until the Supreme Court's decision, which is scheduled as if it is being actively put to sleep. The only way to make the scenario worse is to wait for the court to make a longer-term decision in late June. Presumably, it will be a decision that will require further proceedings and fact-finding on this particular issue before indicting President Trump. However, even a decision at the end of June would be bad enough. It was literally the worst-case scenario for those who would want a jury trial over Trump's actions on Jan. 6. He may literally not be held accountable for that day for the rest of his life. First, he can't afford to let Merrick Garland's Justice Department off the hook before he puts the blame on the federal Supreme Court. In some ways, Donald Trump is absolutely right. His cases should not have been delayed until this year. They should have been heard in early or mid-2023. Many of us have accused Attorney General Garland and the DOJ of apparently doing nothing to decide whether to prosecute anyone in the White House before the end of 2021. If Attorney General Garland had taken office and said our first priority is to investigate January 6th and make sure it doesn't happen again, our first priority is to investigate the January 6th case and make sure it doesn't happen again. If the facts lead to prosecution, we will prosecute. If not, we will not prosecute. The prosecution was to take place before or after the announcement of the special commission in mid-2022. The trial was to take place in 2023. America experienced the greatest crime of the century against our country on 9/11, and on January 6, 2021, we committed the crime of the century against our constitutional government. Without a thorough counter and investigation, we will only invite the next attack. We have never experienced a second 9/11s. They are already calling January 6 the day of dictatorship. Many of us thought Jack Smith's December motion to take Trump's presidential immunity argument directly to the Supreme Court was a clever appeal. He needed an answer to that question to get a jury verdict. He needed a verdict fast enough, important, valuable, and historic enough to be delivered before the November 2024 election. The prevailing view was that the court would accept the case immediately and promptly because of the efficiency and necessity of the answer. This is not an exotic legal question, but merely an unusual set of facts. Questions like this are litigated all the time. When the court issued a one-line order in late December dismissing the direct appeal in the presidential immunity case, we wondered whether the court had already accepted the D.C. Circuit Court's decision and decided to deny President Trump's inevitable request for a rehearing. It made sense. The case was to be heard in the D.C. Court of Appeals next weekend, so it wasn't a hard question to answer. Why would the Supreme Court want to do this? Neither the trial court nor the appeals court had any trouble deciding the issue. 4 highly qualified federal judges heard the case and ruled emphatically against Trump's immunity from prosecution. It doesn't take a law degree to realize that it makes no sense for a former president to be prosecuted for crimes committed while in office. Espionage fraud. It happens in every case where a president can claim legitimacy. And now the Supreme Court has decided that President Trump's case should be heard. That in itself is bad enough, but by dragging out the case for so long, the court has completely abandoned any sign of speeding up the process. Even more problematic, if the court continues to delay the case, the trial could take place as early as mid-September, and there is no guarantee it will take place before the election. If you want to see evidence of far-right courts openly dealing with far-right cases, this is exactly the case. Americans will likely go to the polls without knowing the answer to the question of whether they are for or against the person who committed the crime in the last election. A lot of things had to come together to paint this worst-case scenario. A candidate willing to resort to violence to stay in office, 11 more Republican senators willing to vote yes on Trump's second impeachment, an inexplicably apathetic Justice Department, an even more reckless President Trump, and a Supreme Court willing to support the far right. The situation resembles Swiss cheese. Many holes had to be aligned along the way, but they were aligned. And the Supreme Court was the last, a court that was free to set boundaries. Instead, we got the worst-case scenario. You'd think that if Trump really believed he was innocent, he'd want an acquittal. That's what we have for you today. What do you think of our video? Let us know in the comments section below, and don't forget to subscribe, like and hit that share button.